All right. Today, we're going to dive into a law that gets talked about a lot, but is often misunderstood: California's anti-SLAPP law. Now, it's supposed to be a shield for free speech, right? But could it be used as a sword? We're going to get to the bottom of that. Let's jump right in.
You know what? I'm going to start with the answer right up front. The answer is zero. Nothing. Now just hold on to that number, because figuring out how we get there, well, that's the whole point of this explainer.
So here's the setup. Imagine a court orders someone to cough up $119,000 in legal fees. The big question is, how much of that do they actually owe? As you're about to see, the answer isn't what you'd expect.
Okay, so to understand how we could possibly get to an answer of zero, we have to start with the basics. We have to understand the law at the very center of all this. So what in the world is anti-SLAPP?
First off, anti-SLAPP. It's an acronym. It stands for Strategic Lawsuit Against Public Participation. Honestly, the name itself tells you almost everything you need to know. It's a law designed to stop lawsuits that are filed for purely strategic reasons, basically to bully people into silence. At its heart, this law is all about protecting two fundamental rights: free speech and the right to petition your government. Think about it. Say you stand up and speak your mind at a town hall meeting. If a developer sues you for defamation just to shut you up, this law is meant to be your shield. And it started out focused on public speech, but over time it's grown to cover things like court filings too.
But, and this is a huge but, this is where things get really interesting. This is where most of the confusion comes in. There are some very clear, very critical limits on when you can actually use this law. It's not a free-for-all. Okay, this is absolutely crucial. For anti-SLAPP to even be on the table, three things have to be true. First, there has to be a real proceeding in a court that actually has jurisdiction. Second, there has to be a real, legitimate controversy. And third, and this is the big one for our conversation, the entire case has to be based on a lawful premise.
And this slide really lays it out perfectly. The law draws a super bright line. On one side, you've got protected activities, right? Speaking your mind, participating in debates, filing documents in a legitimate case. But look at the other side. This is what's unprotected. And right at the top of that list, any activity based on fraud, or cases where there's no jurisdiction. That distinction is the whole ballgame.
So let me be crystal clear about this. The anti-SLAPP law is not some magic wand you can wave in every situation. It is not a get-out-of-jail-free card, it isn't automatic, and it is definitely not available for just any old lawsuit. The conditions matter a lot.
And all of this brings us to a landmark decision, a case that went all the way to California's highest court and really cemented a vital exception to this whole rule. The case is called Flatley v. Mauro, and what the California Supreme Court said here fundamentally changed the game. It shapes exactly how the anti-SLAPP statute can, and more importantly, cannot be used.
And here it is, the key sentence. Directly from the court's ruling, I'll read it. Anti-SLAPP does not apply when the conduct is illegal or fraudulent as a matter of law. That's it. It's a hard stop. Period.
But let me break that down even simpler. If a case is built on a foundation of fraud, the whole anti-SLAPP analysis just stops. Dead in its tracks. The protection is off the table because, you know what? Fraud isn't protected speech, it's not protected petitioning, it's just fraud.
So now we have all the pieces of the puzzle. Let's put it all together. Let's connect this back to our original question about that $119,000 fee and see how the law itself leads us straight to the answer.
The logic just flows step by step. Okay, step one, the case we're talking about is built entirely on allegations of fraud. Step two, because of that, the fraud exception from that Flatley case kicks right in. That means, step three, the anti-SLAPP law cannot be legally used to punish someone with fees in this situation, which leads us inevitably to step four, the correct legal fee amount is zero.
And it's so important to get this. This conclusion, this $0, it isn't based on someone's opinion or what feels fair. It's based on the plain text of the law, on a direct precedent from the Supreme Court, and on the fundamental rules of the legal system.
And this brings us to what might be the most powerful way to think about this law. It's a shield. It's there to protect people who are legitimately exercising their rights. It was never, ever intended to be a sword, used offensively to try and manufacture penalties where the legal grounds just don't exist. So, when you boil it all down, here's the ultimate takeaway. The anti-SLAP law is like a scalpel, not a sledgehammer. It's a finely tuned instrument designed to do one thing: defend legitimate public participation. Its purpose is not to create penalties out of thin air, especially in cases tangled up in allegations of fraud. Understanding that difference is everything.
And that leaves us with a final big thought to chew on. The law, as the legislature wrote it and the courts see it, tries to draw a very clear line in the sand. But it does make you wonder, doesn't it? In the world we live in today, just where is that line between protecting legitimate speech and accidentally creating a system that might end up rewarding fraud?